So this is part of a very exciting event. Those of you who joined for the opening, we're really connecting the dots of what is connected already in practice. So it is very exciting to be chairing this session together with Professor Jorge Cabrera from University of Costa Rica, and also legal advisor to the National Biodiversity Institute, and also with Dr. Daniel Ruiz de Garibay Ponce, Senior Lecturer at Asia Pacific University and Associate Fellow of the Biodiversity Law and Governance Initiative. And this shouldn't be seen as just a standalone event. It is one that has been going on for very long. I remember, Marie Claire, when we were in Cancun, the first Biodiversity Law and Governance Day, and which was very well received. And it was a catalytic moment to really bring this forward and see not only COPs, because COPs are limited in time, and our biodiversity, our survival as a species, it's ought to be seen in a long term. So the question that we are going to address in this session in particular is, what are the effects of the Conference of the Parties outcome on law and policy to advance the national biodiversity strategies and action plans, including to address other effective conservation measures? So these were also issues that we addressed during the COP, during the Biodiversity Law and Governance Day. And as we progress, it'll be very interesting to hear from our amazing panel. So first, I would like to give the word to Professor Jorge Cabrera. There were some technical issues, but let's see if he is here to give some initial remarks. Jorge, you there?
So okay. I think we're having a bit of an issue with joining, so Jorge isn't with us yet as a speaker. So maybe
okay, perfect. So then I'll give the word to Dr. Daniel Ruiz de Garibay Ponce to give some initial framing remarks before we go into our panel discussion. Daniel, the floor is yours.
Thank you very much, Claudia. It is my pleasure to be here with this distinguished panel. And we will hear from legal practitioners, policymakers, academics, and also conservation leaders. As Claudia mentioned, our main question today is to analyze the outcomes of the COP. And just to frame the discussion, I would mention that particularly one of the most significant ways in which the COP decisions influence national and legal systems is through the influence that it makes in the national biodiversity plans. And over the years, we have seen how countries have updated their environmental legislation and how they have strengthened institutional frameworks and how they have created new mechanisms for biodiversity conservation. Particularly interesting is the OECMs and how we can see that as legal and policy innovation. We will hear a lot more on that from Harry Jonas, but just suffice to mention that in order for these mechanisms to be effective, they have to be rooted into a strong legal and policy framework that support their implementation. And particularly, implementation is one of the issues that we could actually turn into if we look at the idea of enforcement. So enforcement is something that we could be discussing here with practitioners, and also we could turn into the idea of political will, collective commitment, since we also have some of us here that are advocates. So I think these would be the main ideas, but obviously there probably would be some others that panelists will bring. And actually this is the idea of these discussions, to have a dynamic exchange of ideas. And I look forward to see and to hear from everyone. And now I'll pass the floor back to Claudia, who is speaking now. Thank you very much.
Thank you, Daniel. So now we will hear from Tim Scott, who is Senior Policy Advisor in Environmental Governance at UNDP. One also of the very initial champions talking about this Biodiversity Law and Governance Day, and really thinking about how the UN system can actually help and support countries to implement their commitments. So very keen to hear from you, Tim. Over.
Thanks so much, Claudia. And I also share fond memories of Cancun and many other opportunities to collaborate with you and others. A big hello to colleagues and co-chairs and my fellow speakers in Cambridge and online, and greetings to all participants from wintry New York here at UNDP headquarters. I'm missing that Cali sunshine, I think. Since Cali last October, we've of course all continued to follow preparations for the extended Cali 2.0 COP meetings in Rome. And in parallel, UNDP and all of us have continued to work closely with governments, country stakeholders, sister UN agencies, and other partners to advance NBSAPs. And I know, of course, our focus right now is on NBSAPs and OECMs, but as we heard earlier today, and of course, equally relevant to our discussion, is how we're leveraging the synergies with complementary national and sector planning, including those linked to the other two Rio Convention, COPs, and other conventions as well. So this includes NDCs, land degradation neutrality targets. This includes circular and green economy strategies. This includes more technical work on agriculture, fisheries, oceans, forests, and protected areas, on cross-cutting themes like digitalization and finance, including subsidies, and of course, our meaningful engagement with indigenous peoples, with local communities, with women and youth, small farmers, rangers, and other stakeholders whom we're here to support. And all of these policy entry points are part of the integrated whole of society and whole of governance approaches that were called for by the COP, by the GBF, and by our global community's broader support for a just and green transition. So it's from this policy and governance perspective that I'm pleased to share just a few reflections, and I'll try to stay in my time. First, although Cali did not necessarily provide the best possible outcomes that all countries and communities want, COP decisions did help catalyze, of course, more momentum around the NBSAPs and their implementation. Just to remind, the COP reviewed national targets and the alignment of NBSAPs with the GBF, including, and it was a key catalyst for the submission of 100 national 19 targets and 44 updated NBSAPs. And as we heard earlier, the decision to establish a permanent subsidiary body on Article 8J and other CBD provisions on indigenous peoples and local communities, and a related decision on the role of people of African descent. And I want to underscore this. They represent such an important key procedural, normative, substantive milestone in the CBD negotiation context with direct legal policy and governance implications. Similarly, the decision on operationalizing a multilateral benefit sharing mechanism for digital sequence information on genetic resources and establishing the Cali Fund also represent very significant work that some of our speakers may add on to, although of course much more work is needed to realize these goals. So that was my first reflection. My second reflection is about what the COP has not yet achieved and its implications for NBSAPs. So as we all know, decisions on resource mobilization, the financial mechanism or mechanisms, planning, monitoring, reporting and review, and importantly, the budget decisions were not made on these or finalized in Cali. And of course, the focus for COP 2.0 meetings in Rome later this month. And even if these decisions are made soon in Rome, the divide between countries and regions, including but not limited to North and South divergences, will continue. This is not in the absence of great convergence on many issues, but it's important to note these very strong divides. particularly in the context of the new views of the current U.S. administration on the use of ODA in general and the engagement of the U.S. in particular in multilateral systems and agreements. And in some ways, this only deepens some aspects of that divide while also opening up new opportunities to bridge the divide. So this will continue, of course, to have an impact on how NBSAPs are implemented, including the technical and financial support needed to help countries strengthen their legal and governance systems in line with COP decisions. Which brings me to my third and final reflection, and that is that all of us, both prior to the COP and since its close in early last November, have been supporting many initiatives to help countries update, align, finance, and implement their NBSAPs while ensuring the important synergies with other policy frameworks I mentioned. And so just a few examples: with GEF funding, UNDP and UNEP and other partners are working closely together to support over 120 countries, including SIDS, to submit their NBSAPs and to advance their implementation through strengthened legislation and strengthened cross-sectoral governance systems. And this work is closely linked to work around NDCs and other national and sectoral development frameworks. In over 130 countries, UNDP is also helping countries to design and implement the biodiversity finance plans and finance solutions that are needed to catalyze the better use of both domestic and international public and private funds for the implementation of NBSAPs. And of course, and perhaps most important, together with partners, we continue to support a range of projects in over 100 countries around ABS and around the meaningful engagement of Indigenous peoples and local communities, among other stakeholder groups. We see a gap, though, and with this, Claudia, I'll conclude very quickly and look forward to hearing more from my fellow speakers, is that at least in traditional ODA funding that responds to, there's a gap in traditional ODA funding that responds to significant country demand for support to strengthen and make more coherent national legislation, and more importantly, the enforcement of this legislation across the justice value chain. This includes frontier issues such as the rights of nature and the application of human rights-based approaches. And this is not to say that there are not already many good initiatives going on in these areas. There are, including to support judges, to strengthen the capacities of parliaments, and so on. But there does seem to be an urgent need and opportunity now to scale up these good initiatives and accelerate them within and across countries and regions, which is, of course, key to our focus on advancing the NBSAPs. So with that, thanks again for this chance to contribute, Claudia, and I'll stop there.
Thank you very much, Tim. It's really important to highlight what was achieved, but also what was not achieved, because that's also part of seeing which are the gaps and how can we overcome them. And also in terms of, I mean, as academics, practitioners here, look at the elements of convergence, but also of divergence, because unless we put them in the table and really take them seriously and try to understand what the other part is trying to say or where do they come from, we won't get too far, and we will get into this division between north, south, that you were speaking about in terms of how do we get forward, including in issues such as financing. And what you said also in terms of this justice and human rights-based approach, also learning from previous experience. And I mean, UNDP together with UNEP and others have been also supporting processes. And I was very pleased to be part of that initiative, for example, in the context of the Escazú Agreement on information, participation, access to justice, recognizing this right to a clean, healthy, and sustainable environment. So how can we see also what are the institutional laws and policies that we have in place to actually make this change possible, and also in terms of implementing what the Global Biodiversity Framework already kind of committed to. So without further ado, I will give the word to Advocate Nina Pindam. She's a barrister from Cornerstone Chambers. So as with all the speakers, we have 5 minutes just to make sure that we have enough space also then for the questions and answers. And in the spirit of making our dialogue really a dialogue between everyone, including those that are not lawyers, that are coming from different disciplines and so on, I encourage you to avoid using acronyms and try to be as direct as possible. That's something that we have been also hearing from other sessions, and we have a very diverse group here, so that's an encouragement. So Nina, you have the floor.
Oh, I'm in the room. Not the room, I'm sorry, but that's exactly what happened in Paris. I mean, we were speaking to the screen before, so we're used to it. If you can't, the microphone's some distance away, so please ping a message if you can't hear me. But I ought to know how to project being a barrister. I have 5 minutes. I'm going to take less because we had a late start and the discussion is really what I want to get into. I'm going to take it away from the high level, wonderful overview that we've just had from Tim and start with something really quite crunchy, because as a practitioner, I'm interested in what works. And the timing is fortuitous. So next week is the 1-year anniversary of a new law that we've just had implemented in England. It's called the Biodiversity Net Gain Law. And what that is in a nutshell is a 10% net gain. So in reality, 110% provision of biodiversity, both post-development on land that is developed in England. This is a massive regime. It covers pretty much every development. So a single dwelling house still is subject to the biodiversity net gain regime, must provide 110% biodiversity after the development is completed. How that's done, there's an Excel spreadsheet. It's very simplified. It uses static habitat areas as a proxy for species interest and abundance. So the types of habitat that are on the site are put into this Excel spreadsheet, very complicated. So I'm simplifying dramatically, but it's user-friendly. All the mechanisms are internal, so it calculates automatically what units are on the site and therefore what units you need to secure legally at the end of it. In most cases, they're I'll simplify it dramatically, but it's a legal regime and the output is legally required and therefore legally enforceable. We're all lawyers. We really love that it is enforceable as a matter of law. This is genuinely world leading. I looked for a model elsewhere that was like this. There isn't. There's a lot of no net loss. There's some biodiversity gain as a requirement of law. Most of it's policy based, but there is nothing as wide ranging and legally robust as this anywhere else in the world. A global version of the metric was presented at Cali, COP16, and then also in Baku at COP29. I think really critical to this, so getting to my key points, is that throughout the legislative development of this, scientists were involved at every single juncture. I cannot tell the room and the audience listening how many times I've been in court arguing that scientific unicorns exist because the law was drafted by somebody who had no idea what the science actually was. And the law, therefore, not only didn't actually accurately represent science, but it did not achieve the outcomes that it sought to because it wasn't informed by the scientists who know what the reality requires. And that's particularly the case with biodiversity, which is so complicated. So what's the result? It has been an absolute game changer in England. I didn't expect to see the difference it has made in just a year. From being treated as we had biodiversity net gain as a policy requirement before, having it now just as a legal requirement has completely changed the development industry. Before it was an afterthought, now it is, what site do you develop? Where do you develop on that site? What do you do as part of that development? It is treated as an imperative at the very, very beginning of the process. We'll see the full outcome in 30 years, but already has completely changed the mindset of development in England. And here I'm going to make a provocative point because we're here to have a discussion. I think one of the reasons why it's so effective is it is an outcome-based law as opposed to a procedure-based law. And lawyers were much more comfortable with procedural laws as opposed to outcome-focused because we think outcomes are up to the legislatures, and that's absolutely right. But if the legislature chooses to put an outcome or a target in law, then of course it's full square within a lawyer's domain. And then final point is it cannot be future looking. We have a lot of future looking legal targets, but this being an immediate legal requirement has been why it has been such a game changer, because it doesn't mean nobody can push the can down the road. You need to immediately address it and achieve that outcome right away. So to sum up the point I'm trying to make, looking ahead to what is going to be what is, I think, now dubbed the Nature COP in Belém, participants really need to shift to focusing on implementation. We hear that as a trend in every talk today. Focus on implementation over negotiation. We are at that crunch point now, and I mean legal implementation. As a practitioner, I can say policy is not working, but the law is. So this is a very happy case study on what works, an outcome-based law made at the top, implemented and enforced throughout the system, down to the very local decisions being made affecting specific land. And that, bringing my contribution full circle, is an example of turning what hasn't worked and implementing something that does. Thank you.
Thank you so much, Nina. And I love that you bring this kind of more controversial points and seeing what hasn't worked and what can work, because I think the moment we do that, we start to be honest with the limitations that we have. And what we were talking about before is also your question in this assumption that everything will come from international law and then be decided at the national law, but also how innovations from national context can fit into the international one. And feel free for the next speakers also to engage with the points that you just heard. I see some faces there already nodding and others kind of with a question mark, whether that's the case, which I love. So that's really interesting. And I mean, talking about immediate and long term, I think that's a question that it's at the core. If we don't act now, we will also affect the long term. So it's not either one or the other, but let's see what works. So I would like to give the word now to Advocate Caio Borges. He's Regional Director of File Foundation. So Caio, the floor is yours.
I think Caio hit technical difficulties.
Yes,
okay.
Unfortunately, Caio hasn't been able to join us, so maybe we can skip ahead on to the next speaker.
Okay, thank you. So then we'll give the word to Advocate Christina Pack. She's the principal.
No, she's also.
Okay.
Christina also.
I have an old agenda.
Okay. So then to Britta Sjøstedt, who it's nice we work just across the street, and we have all these engaging discussions, and it's so nice to be here with a broader group. She's a senior lecturer in environmental law at the Lund University. So Britta, the floor is yours.
Yes, so thank you so much, and thank you also for inviting me to this round table discussion. I think it's I hope it will be super interesting. It's been great so far. So what I would like to raise is some of the implementation challenges, but I will sort of zoom out a little bit and look more at the structure of MEAs in general, so multilateral environmental agreements like the CBD. So usually MEAs work from this structure of frameworks agreements with using sort of the obligation of conducts and open-ended discussion or open-ended provision that needs to be developed with content at, for instance, COPs through the decisions and the negotiations. And I would like to raise some of the issues that I think is a bit problematic about this approach. I will also sort of highlight a few of the advantage that it also has. But I think some of these things might go a little bit in line with what Nina just raised about the sort of conduct versus result-based obligations. So to have conduct-oriented obligations rather than result-based obligation, it means that we look at how states actually, from an international point of view, look at how states perform given the context, the challenges that they are facing, and how they can act in accordance with their capacities or capabilities. And this means that it can be quite challenging to establish if we have a breach of the violation, like of the provisions that are provided in these instruments. When it comes to other areas of international law, we can determine when there is a breach of international obligation, and then we can through the rules of state responsibility, demand certain actions, which is quite difficult when it comes to MEAs that works from a little bit of a different rationale with having this type of obligation. And so the first point that I try to make here is that it's hard to establish the breach, because we have to sort of see it from the capabilities of these states, and with obligation using a language such as that states should, as far as possible or as appropriate, act in a certain way. So we have this sort of obligation of conduct that we see more what they are able to do rather than like result-based obligations. So I think that, together with the fact that a lot of MEAs don't have concrete sanctions if they don't live up to the obligation, that is problematic to for reasons of state responsibility, and we seldom see state-to-state dispute settlements unless there is a transboundary damage situation. So instead, as we all know, the MEAs like CBD, they use other mechanisms to sort of encourage or ensure compliance, and that is through assisting state parties. And this could be sort of, as we have heard about, projects, programs, technology transfer, capacity building, financial assistance. And of course, this can be an advantage to adapt to certain needs for the state parties to actually live up to their obligation. But there's also a problem that we often see, that often the resources is not enough to support all of these states that are not able to live up to their obligations. And I think also when we have the type of conduct obligations, they're also problematic, because when we don't have the concrete result based obligations, it's quite difficult to see the actual progress. And I think this was something that was meant to be different. So if we compare, for instance, the Aichi biodiversity targets, where we saw that many states actually didn't live up to them in the end, with the global biodiversity framework, this was something that wanted to be avoided. But it seems like it's not really the case. And I know, Tim, you raised this as a positive outcome, that there were many states that did submit their national biodiversity strategy and action plans. But in fact, it was only 44 out of 196 parties. So I don't know if I could really say that that is a successful outcome. And particularly since my own country, Sweden, that is normally known to be good at this to this type of performance, did not submit. And I think, yeah, they were not alone, and this was like big news in Sweden actually. So, and also, what, as far as I understand, and please correct me if I'm wrong, I think also that the plans that were submitted, that a lot of it was actually being reused from previous plans. So I'm not convinced that it actually meant so much in practice. And then a second thing that I want to raise before I sort of conclude.
So, Britta, we're already.
Sorry. Then I will stop
already
there.
Yeah. Thanks.
Thank you.
No. Yeah, just wrap up your final point, please.
Oh, sorry. Oh, yeah. No, I will be very brief. No, I think the last thing is that the other thing that I think it's a bit problematic having this type of framework convention, and this is not just the CBD, but with all the frameworks convention, the other Rio convention, but there are many other MEAs that works in a similar way. We have so many COPs and it's so many negotiations that result in many different tools, programs, funds, guidelines, decisions, that I think this area is becoming very fragmented, although there is all of this will to have synergies between all of these conventions. I do think it is hard to keep up with all what's being produced and to actually like have a coherent approach where you take into account all of this that actually exists. So I wonder if it's sometimes not so, like my question is if this is really like an efficient way of working, and maybe we should think of other ways of doing these things. But I will stop there, and sorry if I went over time.
Thank you, Britta. And it's really nice to see the interconnections between what's happening at the national level and what we can learn to address some of the challenges also that Britta raised. And also remember, like, how did negotiations, for instance, for the Global Biodiversity Framework came about? There was a strong push in the beginning to have a compliance committee of review and implementation. And at the end, countries didn't manage to get there. So we see that that's a significant challenge. And I mean, you raised very important issues, Britta, and we're just moving along the multilateral environmental agreements. The fragmentation, if we bring human rights law, for example, or economic instruments that all need to be in the table if we want to really address the root causes. So I think many of the issues that you're bringing are not only relevant for the Biodiversity Convention, but also for the other conventions that we are addressing, and also what we were discussing in the morning in terms of the connections between multilateral environmental agreements, economic instruments, and human rights law. So thanks a lot for that. Now I will give the word to Dr. Harry Jonas, Senior Director of WWF and co-chair of the IUCN Specialist Group on Other Effective Area Conservation Measures. And it's great to have you here, Harry. And I mean, you have also a long history of connecting multilateral environmental agreements and human rights law, which I think it really brings the discussion into a broader perspective, and also in terms of really implementation, that's what you have been very effective on doing. So over to you, Harry.
Thanks, Claudia. And hello, everybody in Cambridge and all of those of you online. Yeah, no, this is great. Really, really interesting session. Thanks so much for the invite as well. Yeah, I'm gonna talk through the advancements we've seen in the recognition of conservation beyond protected areas through the CBD. I cannot avoid an acronym because I will be speaking about something called other effective area-based conservation measures that I will reduce to OECMs, but otherwise I will stick to most of the rules. Thanks. Also, the one thing I want to add, also particularly probably for students on the line, is that whilst we often talk about substance and laws and policies, as you've heard in some of the presentations already today, there's a lot of practical and practice here about how we actually advance that. So I enjoy thinking about the how, and I'm going to speak a little bit to that as well. So I'm talking about the work, the substance, but also building a field for this work. So, you know, I'm going to talk about other effective area-based conservation measures. I always like to begin with the main takeaway, and that is we are building a real means by which to better recognize conservation, effective conservation occurring outside of protected areas. Something which is vitally, vitally important. So let me begin with protected areas, and that is to say that many of us, likely all of us on these calls have visited one or more protected area. They're very beautiful places, and when managed effectively, they are very good at conserving biodiversity. But in one sentence, let me underscore the following. You know, without other means of recognizing conservation efforts, the framework can be applied in ways that can be inappropriate, and in some instances can and has led to human rights abuses. And if you are up on that story, you'll know what I'm talking about. And if not, feel free to Google around it. You'll find some very interesting thinking around conservation justice. And so going back to CBD, the 10th COP, where they agreed 20 Aichi targets, target 11 looked at area-based conservation. And the target then was to achieve 17% of terrestrial areas, 10% of marine areas through protected areas, or at least that's what a lot of people took away from looking at the text that you've got on screen. But actually, when you reread that, there was another phrase that was put in there. It actually didn't just talk about protected areas. CBD Party said we need to look at protected areas and other effective area-based conservation measures. Friends, there was no definition of what that additional phrase meant. And so sort of beginning in 2012 and ultimately published in 2014, a few of us working on these issues said, hey, if we could retroactively define that term, we may do the world a service, and we may be able, through that future framework, better recognize these important conservation areas managed by diverse governance authorities. And that happened, actually. I won't bore you with that background, but there was a process, and a good number of us were well involved in that, and that resulted in 2018 in a definition, a set of criteria for an other effective area-based conservation measure, an OECM. And when you boil down that definition, basically what you end up with is a site that delivers the conservation of biodiversity, the long-term conservation outside of a protected area, very simply put. And why that is important is that, as I said before, protected areas cannot and are not appropriate as a designation for many different areas. And so once upon a time, we used to look at landscapes and really you'd see these green polygons on maps that were protected areas. And those were the places that were most important, viewed by some people. And I just, through my work and many others, felt there were a lot of other places that should be better recognized. And so when you have more of a plural approach to conservation, you recognize PAs, you can also recognize these other equally important places. So in terms of building the field, those of you online, it's really, you've heard different approaches to that, which I've really appreciated. Our approach was really to work through the IUCN commissions, particularly the World Commission on Protected Areas, that develops a lot of advice that's seen as being, potentially universally applied. So we developed the guidelines that took the CBD decision 14.8, turned it into guidelines that people could apply, which they've been doing, and racing ahead with the story to fit within the 5 minutes. We were at COP16 and provided some updates to colleagues there. We produced the first scientific paper that assessed the contribution of OECMs, these places outside of protected areas, to the new target 3, which is the 30 by 30 target, the target to conserve at least 30% of the Earth by 2030. And we found some quite startling things in such a short amount of time. 15.
Kari,
Yeah.
Kari, just a clarification that, we wanted to go more in depth on other effective conservation measures. So that's why you have 10 minutes. So just bear that in mind.
All good. We're, adaptive management on this side of the world. And so I'll still probably deliver the next couple of minutes, and then we can get into it more deeply if we'd like to. So friends, by the numbers, so 15 countries already, you can see on the map here, have identified and reported almost 6,500 sites to the World Database on OECMs, which is happily based in Cambridge. That already covers almost 2 million square kilometers of the Earth's surface. Claudia, you're from Mexico, and that's about the same size as the terrestrial area of Mexico. And that covers already about 1% of the Earth's landmass. The governance thinking was super interesting. If you look down at the bottom there, about 2.5% of protected areas reported have a shared form of governance between government agencies and others, already in the OECMs that have been reported. There's a very high percentage, just over 40% of sites that have been reported have got some form of shared governance, which is, I think, really interesting. And key biodiversity areas are areas that are sort of scientifically assessed to say, regardless of what this area is or who governs it, this is a very, very important area for biodiversity. And 30% of the sites that have been submitted overlap with key biodiversity areas. So that, again, that also shows that a really high proportion of these OECMs are being reported in places that have got very high, very, very important biodiversity. In fact, I have finished already. That is the last slide, having zoomed through and cut a few out. That tells you part of the story, friends, because the OECM framework, as you heard, was referenced in 2010, was agreed in 2018, and now that is well embedded in Target 3, the 30 by 30 target. But friends, the 30 by 30 target, now the text is that you can achieve the 30 by 30 target through protected areas, OECMs, recognizing indigenous and traditional territories, okay? And so colleagues, in fact, that I've spent the last 3 days here in DC are working very intensively on how to then develop out criteria and a definition for ITTs, another acronym, indigenous and traditional territories, so that if they wanted an indigenous people in one or other country could say, hey, first of all, our territory is conserving biodiversity, globally important ways, but we don't want to be recognized as a protected area, and for whatever reason, we don't want to be identified as an OECM. We want to be recognized as an indigenous and traditional territory, and if so, they should be able to do that. And so that feels like the next horizon, and I feel strongly that we will get there before 2030. So thanks very much. That's me. Find me on LinkedIn if you'd like to connect more and go from there. Thank you so much. Claudia, back to you.
Thank you, Harry. And what you have highlighted also gives us hints of what has worked. I mean, there are many issues that have not worked, and Britta also highlighted, I mean, the IT targets, none of the IT targets were fully complied with. So that really rings the bell of that's what we can't let happen when it comes to the global biodiversity framework. So seeing seeds of what it's working is really important. And it's great to have with us Elena Cox, which links to your last point, Harry, in terms of hearing the indigenous people's wisdom, but also the youth coming into these discussions. So Elena Cox is part of the Youth Advisory Council and also the Jane Goodall Institute of Canada and Indigenous Leadership Commission member. So over to you.
Thank you so much for the introduction. I would definitely like to speak more about what the other panelists have been able to talk about in regard to the importance of COPs and also Indigenous protected and conserved areas. So as developments in law and policy, they occur on both national and international levels, it actually causes need for amendments to existing laws and policies. In the case of the Convention of Biological Diversity and the Kunming-Montreal Framework, changes were required in order to implement more Indigenous values, perspectives, and ideals to align with the United Nations Declaration on the Rights of Indigenous Peoples. Although the process of the creation for the Kunming-Montreal Framework was not the most inclusive of local Indigenous communities, I myself was there and I spoke to a lot of communities about some upsetting actions that were taken at this event. It still worked to create an updated framework that mentioned Indigenous peoples more frequently than the original text of the Convention on Biological Diversity. The original convention in 2011 mentioned more frequently the use of Indigenous traditional knowledge, whereas the Kunming-Montreal framework was developed at a time where the hosting country of Canada, where I live, has recently implemented, the year before, their national legislation for the United Nations Declaration on the Rights of Indigenous People, which is more, and the Kunming-Montreal framework then became more representative of Indigenous rights, including the right over traditional territories, rather than just talking about inclusion of traditional knowledge. Happily, the following conference in Cali, Colombia, work to further and more actively include Indigenous and local communities through the new adopted program of work and increase funding opportunities to ensure more meaningful contributions towards the Convention of Biological Diversity and its targets. A method in which Indigenous communities exercise their right to traditional territories is through the use of Indigenous Protected and Conserved Areas, or an IPCA, which in academia have actually previously been referred to as other effective conservation measures, or OECMs. Since IPCAs still face many challenges regarding their lack of national legal framework, the different methods that are used in their designation, reporting, and monitoring, they are not often considered as a protected area, but as an OECM and a method of in situ conservation. So IPCAs may differ from one another, just as Indigenous communities differ from one another. However, they all share three very essential elements that are being Indigenous-led, represent a long-term commitment to conservation, and they elevate the rights and responsibilities of Indigenous and local communities, which is especially important since Indigenous people have been historically included from conservation decisions, in addition to being forcefully removed from their homelands and stripped of culture and identity. An IPCA provides not only the opportunity for Indigenous communities to reconnect with their territory and their cultures that were stolen, but also to contribute to national targets, such as reaching 30% of land and water being conserved by 2030. In addition to providing Indigenous communities safety, job security, and reconnection, it aligns with the goals of the United Nations Declaration on the Rights of Indigenous Peoples. If all IPCAs were legally protected, for example, even self-declared ones, like Grassy Narrows First Nations IPCA, which was declared in Ontario to protect the nation's territory and to combat the government's non-consensual mining that caused mercury poisoning in the community for the last 60 years, then these protections would largely contribute to meeting both national and international reconciliation goals and biodiversity targets. So, thank you.
Thank you so much. And this gives us a broad range of reasons why it is so critical to hear, to learn, to co-create with the Indigenous people and local communities, and with the last COP, also Afro-descendant communities. That was a big fight in the COP. And if we think about countries such as Colombia, many Latin American countries, but also others, bringing those voices into the picture allows us to really achieve not only the goals, but achieve them in a just manner. So the justice aspect should definitely be on the table, as you are highlighting. So thank you, Lina. Now I would like to give the word to Advocate Kelly Sporn. She is Solicitor and Sustainability Policy and Strategy Specialist. So the floor is yours, Kelly.
Thank you. I noted that today there's been a lot of discussion about the importance of there actually being effective action happening in relation to what we're seeing in biodiversity, and something that takes into account lots of different viewpoints. One of the things that has been discussed for a long time around the biodiversity COPs in particular is the importance of mainstreaming biodiversity, making sure that it becomes central to decision making. And often that's talked about mainly from the perspective of governments. But for that to be genuinely effective, it's also got to involve the private sector as well. And that's the point of view I'd like to represent here. I used to be a capital markets and derivatives lawyer. I was amused about the admonition before to say, please don't use acronyms, because I didn't think there was anything that used more acronyms than derivatives until I got into sustainability. That's turned into a whole new world. But the transition of my own career is a useful insight into how domestic responses to COPs can actually make a big difference in terms of how businesses are responding. So the bank I was at, there were, I would have said, maybe 3 or 4 people in the entire bank that were talking about sustainability in any meaningful way when I started. It was following on from Paris Agreement a couple of years beforehand. But the thing that really changed everything was when the UK, in the form of the Bank of England, introduced the concept of climate financial risk into supervisory policy. And also at the same time, the EU introduced what was called the Sustainable Finance Action Plan, which was a fairly comprehensive program of policy that was designed to mainstream the concept of sustainability, start looking about how sustainability risk and opportunities were being factored into the private sector, and also how this was being thought about as something where capital flows would be directed. In the time that I was at the bank, I witnessed that 3 people go to around about 300 across the whole of the bank. And my whole career changed. I'm no longer call myself a capital markets lawyer anymore. That's an indication of how the power that you may not necessarily see of laws being put in place before you even start talking about enforcement. Now, we haven't seen exactly the same kind of thing specifically looking at biodiversity so far. We have had examples of it, and Nina raised a really good example earlier when we were talking about biodiversity net gain in England and Wales and the UK, which is specifically focused there on really on where you've got the interface of the private sector with nature directly. But the thing we haven't seen as much of is what kind of regulations and law can be applied to the private sector when it comes to indirect impact. The main area from what I've looked at in my research, the main policy lever that's been used has been disclosure, and there's a lot of disclosure regulations. I think there's something like, I saw one study that said that there's over 300 sustainability mandatory reporting requirements in 70 countries at the moment. So there's a lot, but a lot of the times those don't necessarily have the teeth that is required to make effective change. That can be coming because they're not being enforced properly. There might be provisions that are available in the laws that enable regulators to enforce them, but it's not happening. But I would also argue a lot of the time what's happening is that they're not being constructed in such a way that mean that businesses actually have to change as a result, because the people that are collecting the data that is required for disclosure are often not necessarily delivering that up to the top of the house in such a way that they're able to mainstream these nature-related decisions into strategic decision making. So this is the one thing I'd like to see the most of in the next couple of years. We may start seeing more reactions coming out of policymakers following Cali 2.0, because I think the focus of the discussions that we had in Cali means that it probably wasn't quite as much, the indirect impact wasn't being considered quite as much. So hopefully we'll start seeing more of that over the next year. But that is one of the areas where we could look at what the role of law is to generate genuine change, where we're actually seeing regulations that are put in place that create the right kind of incentives, both positive and negative incentives that mean that we actually see businesses start taking nature seriously and as part of their strategic decision making.
Thank you, Kelly. It's really thought-provoking. I mean, we have been talking so much about state laws and policies, but as you highlight, if some of these drivers, when it comes to production, consumption, financing, are not tackled, we will not get as far. And here, Target 15, that talks specifically about transnational companies and disclosure, but also, as you highlight, there are limits when it comes to disclosure. But I mean, what is interesting about Target 15 is that also talks about outcome. And this brings us to what you were highlighting. Okay, should we regulate procedurally or more in terms of outcome? That it's something that is coming up in various of the presentations, and this may be something that we want to follow up. And it's critical, again, if we want long-term change and impactful for people and nature. So I will now give the word to Advocate Lucia Salazar Gomez, who is alumna from University of Cambridge. Lucia, over to you.
Thank you. Good afternoon, everyone joining in this session. Thank you also to the CISDL team for the invite. And basically, I want to start by stressing that the national biodiversity strategies and action plans are fundamental mechanisms designed to foster conservation and sustainable use of biodiversity at a national level. But they serve as tools for decision-making all together with other instruments like national reporting target evaluations, cooperation mechanisms, and partnerships. So altogether, decided at a national level, among other multifunctional levels with other countries. Importantly, these frameworks place decision-making responsibilities at the national level among parties. However, as mentioned before, they are not binding instruments, so their success heavily relies on what it has mentioned also before, the political will of the parties for the CBD, capacity building and adequate funding, especially in developing countries. So recalling what has happened at COP16, we have to remember that there were 31 agenda points discussed on critical issues that were urged, the need for the parties, and one of them was fundamentally to adopt revised and updated NBSAPs aligned with the Kunming-Montreal Global Biodiversity Framework, as per decision 15/6. The integration of biodiversity across sectors aim to promote a holistic and integrated approach to conservation, ensuring policies, plans, and programs are effectively aligned with the CBD Article 6, literal B, and additionally to the Article 6A, which basically emphasize that each party should develop the NBSAPs in accordance with their particular conditions and capabilities. While it is essential to work towards a shared global goal, each NBSAP remains unique in assessing ecosystem dynamics, their governance, and implementation mechanisms. As for now, just to be updated with the results, we have 46 parties that have already submitted updated NBSAPs, and 123 submitted national targets, because there was a discretion from the CBD Secretariat that if parties didn't have the updated NBSAPs, they could also submit the national targets. Nevertheless, the shortfall is concerning because submission reflects commitment, and delays, including by the three from the G7 nations and key biodiversity hotspots, highlight gaps in global biodiversity governance. The absence of submissions from Amazon and Congo Basin countries further underlines the need for a stronger political will and legal frameworks, as mentioned before. COP16 was dubbed the People's Cup for its emphasis on empowering rights holders to engage actively in biodiversity governance. Effective governance requires inclusive decision-making, equitable access to finance, and capacity building. However, NBSAPs often include only symbolic references. This was highlighted by the Women's Caucus, basically because NBSAPs currently only address symbolic reference to indigenous peoples and local communities' rights, women, and youth. Instead, we need tangible solutions that promote inclusive governance and ensure meaningful participation and decision-making. The establishment of a permanent subsidiary body under Article 8J of the CBD was radically transformative, because it was formerly an ad hoc working group, and this body now formally integrates traditional knowledge into governance, enhancing the legitimacy and efficacy of biodiversity policies. It is critical to note that indigenous peoples and local communities are recognized and as right holders in the CBD, not merely stakeholders like businesses or even NGOs. Moreover, COP16 established a new program of work on Article 8J to safeguard the rights, contribution, and knowledges from indigenous peoples and local communities. Furthermore, from what we have as outcomes from the COP16, the COP16, as mentioned before, also about the other effective conservation measures. COP16.
Lucia, sorry, could you start wrapping up because we have reached the 5 minutes and we want to give some space also for questions.
Yeah. Okay, so perfect. Well, I'm going then to highlight just my other recommendations that are also related to previous people who already mentioned this. Basically, what we need is to develop effective domestic laws and policies, leverage what we know that it's the clearinghouse mechanisms, that it's going to be supportive for implementation of the NBSAPs, including scientific evidence, participatory approaches, and technical cooperation. Integrate biodiversity into sectoral and cross-sectoral activities. Acknowledge diverse conservation practices, such as the OECMs that we already heard of. Also, transform the voluntary mechanisms like the Cali Fund into binding agreements at a national scope, as we have heard that the UK did that, and it's possible to transform a non-legally binding measure from an international scope to a legally binding measure at a national scope. Also, ensure developed countries support capacity building and provide reliable financial support to developing nations. And finally, foster inclusive governance by guaranteeing the participation of right holders in biodiversity formulation. In closing, COP16 was provided as a framework that was very innovative. Fundamentally, as a People's COP, it highlighted human rights approaches, gender approaches in benefit of the planet and persons. Thank you very much.
Thank you so much, Lucia. And I think it's good that we end up with some very concrete recommendations. And we will now open the floor for questions, both in terms of the people here in the room and also online. So if we can hear first from our moderators online, if there has been any question posted.
Hi, yes. So there was a question from Dr. Anirudh Janagam, an environmental and climate advocate from India. And the question is, how can we move beyond voluntary pledges to legally binding enforcement for biodiversity, climate, and land restoration? And then the second part of that question is, should we push for a global environmental treaty that integrates the Kunming-Montreal Framework, Paris Agreement, and the UNCCD targets into a unified enforceable legal system with compliance mechanisms, penalties, and an independent tribunal to hold nations and corporations accountable?
Thank you, Annabelle. Yeah, it's a very question with different dimensions. Is there any other? So, I mean, we have limited time just to ensure that we really hear from others in the online session as well.
The only other question was, can we reference the English legislation that was cited? So that's more, and that was it.
Okay, thanks a lot. So we'll now take some questions here from the room. Comments, over to you.
I guess with respect to
if you can just introduce yourself and then ask the question. Thank you.
My name is Puya. I'm an LLM student here at the University of Cambridge with a focus on international law and climate change. My question with respect to the development law and the on 110%, I'm curious because the argument that developers always raise is that any form of tax or charge or restriction on development doesn't actually lead to sort of what people think it does, because there's just less development as a result. So they say the less requirements, the better, because we need more housing, et cetera, et cetera. So I'm wondering if in the outcomes of that year, whether we know development decreased or in fact it remained the same, because if it remained the same, it's an argument for these types of interventions.
Thank you. Any other?
Well, I could ask. I'd be really interested.
You get to introduce yourself.
Oh, sorry. Hello, everyone. I'm Emily Morrison. I'm a project lawyer at the International Bar Association. I was wondering if any of the experts are aware of sort of concrete legal mechanisms that do enable that really effective participation of Indigenous peoples. It was really helpful to hear a concrete sort of national example from Nina in the biodiversity net gain space, but is there something else that like the global community could learn from in that regard?
Can I add to that question? It's the same question, just a little bit more focused, because Elena has done some incredible work on that. And I'm not just saying that as the professor who guided her master's work. If she could give an example of the best IPCA that she saw when she was literally going to each of them and finding out what was going on, and then some of the recommendations that she had for, you know, between the best and the worst, if you know what I mean. Because I think you found some really good examples.
Okay, so we don't have any further questions. So I'll give the word again to each of the speakers. So we have around 10 minutes to go, and also at the end, also Daniel, as part of the co-chairs, may want to give some final remarks, and I'll also give some final remarks. So anybody that would like to start by addressing some of the questions, and at the end, also wrapping up if you have any final remarks. Okay, I see Tim, and I see Kelly as well. So Tim, over to you.
Thanks, Claudia, and thanks everyone for the great presentations. I'll try to respond very briefly to, I think it was Anurab from India, our climate expert there, although the question deserves its entire webinar unto itself. So I think for me, what resonated most in your good question, Arnab, was the question of accountability. But rather than focusing on global accountability or accountability at the global level to global agreements, I think perhaps a more feasible but still challenging approach is to focus on national means of accountability, given the, you know, the challenge of global consensus. And that also goes to your good suggestion. It has been made before on the option for a global environmental convention. In principle, it might work. In practice, it might be extremely difficult. So alternatively, and in parallel to any attempts, there have been attempts or issues raised by the government of France, as some may recall. Perhaps a more feasible or a more immediate traction is to look at synergies in the implementation of the existing conventions, not only Rio, but others. And this is where there's been a large focus, at least coming from the UN system and partners that the UN works with, in trying to align nationally determined contributions and national biodiversity strategies and action plans and other commitments to other environmental conventions. Thanks. I'll leave it there.
Thank you, Tim. Kelly? We can't hear you.
Sorry, I've got a double mute thing here that I forgot to press the second button, so sorry about that. I wanted to pick up actually on a couple of points. One was the question we had from India about what more can be done to turn things into something more concrete, and also to the question in the room about what developers have been saying about biodiversity net gain and how that will reduce development. My first job was in frontline politics. I've also worked as a lobbyist, so I've both been lobbied to and I've done the lobbying. And one of the things that is important to remember with everything that happens in regulation and policy in this area is that it takes a systems thinking kind of approach, which anyone who's been through CISO will be very familiar with. But it's actually systems thinking is now underpinning what's happening in sustainability policy in a number of different domestic policymakers. Why that's important, particularly in the context of that point about developers, is that it could very well be that development has gone down, but actually looking at that one metric is never going to be the right way of looking at it when it comes to sustainability. The really important thing is to be able to look at what's the holistic impact of it. When you're a lobbyist, you're taught to come up with the simplest story, to come up with the one thing that's going to sound like it's going to have the biggest impact. But actually, the simple stories are the things we should be the most suspicious of, and any kind of regulation or policy that purports to deal with anything from one angle is going to fail because of the complexity of this. So there is a lot that can be done. There's a lot of lessons that can be learned from what's already happened generally with specific laws, but those laws must always be looked at in that holistic context.
Thank you. Any other interventions to answer the question or just to wrap up some of your main points?
Yes, if I can speak, sorry, I do have to hop off in 5 minutes, but I also just wanted to mention that just with the questions, especially the one online, it had me thinking about when I was working on my thesis and I was looking at what conventions were legally binding and not, and what kind of things we could do in order to have IPCAs be more formally established and legally recognized. And a big part of it was that one thing is the Paris Agreement is legally binding, but the Convention on Biological Diversity is not unless it's ratified into the national capacity. So as Canada, when they had UNDRIP and they had the Convention on Biological Diversity come in, it's not legally binding, but as we can see, since the Paris Agreement is legally binding and we have to do the NDCs every year, you can see a lot of countries that don't meet those commitments actually just dropping off because it's legally binding, but there's no penalties. So I think that the best thing to do moving forward would be for legally binding agreements, such as the Paris Agreement, is having some sort of penalty on countries that don't meet these targets but commit to them. So that's just my opinion on that. It's quite a strong opinion, but I definitely think that if we want to have immediate action, especially by 2030, a big importance is having some sort of penalty that's not just, oh, you didn't meet it, let's just exceed it to the next year and increase it, because it doesn't seem to be working at the moment.
Thank you. And that links very much also to what Britta was saying in terms of these framework conventions. And I mean, it's worth mentioning that the Convention on Biological Diversity did follow all the process of signature, ratification in terms of what is stated by the Vienna Convention of the Law of Treaties, while being a framework convention with the challenges that Britta mentioned. So over to you, Britta. Some of, I mean, because it seems to be connected from these last insights, which are very important, and also linked to what you were making your intervention, which were very important in terms of how do we make this work at the national level in terms of Indigenous people and local communities, and also showing that, I mean, the issue of Indigenous people and local communities is not only a global South issue, it's also very much at the core of global North countries when it comes to Canada. I mean, Britta might want to say something about Sweden and other global North countries. So over to you, Britta.
Yes, so thank you very much. And yeah, I think so far there's been very interesting intervention here. Yeah, so I guess the first point when it comes to Indigenous people in the global North, like in Sweden. So I was actually like wondering, and this is like perhaps also a question to Eliana and Lucia in particular, regarding Indigenous people and the developments taking place under the CBD and the global biodiversity framework. I was wondering, like a country like Sweden, where we have not ratified the ILO convention, and our indigenous population that many are not so aware of, the Sami people, they are like, a lot of their rights are being denied that they have, like if we look on an international level. So I was wondering, like, if the CBD convention and the agreements that have followed, if that could be sort of a way to strengthen their human rights as well, and not just rights linked to conservation. So that was like one thought that I was wondering, especially with this adopted program on Article 8J and the developments taking place there. And then just to respond to like the other comments that was made regarding like a global treaty on environmental law, like a more global, and also like the bindingness of conventions. I think when it comes to international environmental law, we do have this divide between global south and global north. And I think that is really like the reason why we don't have a global instrument today. I think there's just so much of a division there when it comes to conservation issues that can be linked like with the colonial history as well, and the climate negotiations as well. So I think even though I criticize the framework convention sort of mode of being, I think that is the solution that we are that we are able to manage, because that leaves all the difficult questions to later for further negotiation. So that is like, it's a practical reality. And I think right now with the situation we're having with what the US is doing and what's happening there and globally with all the populist movement, I think right now it won't be like the time to negotiate this type of treaty, although we would really wish to have it, to have a more holistic approach to environmental protection on a global level. And I also I would like to disagree a little bit with what Eliana said. Like, I do think like a convention like the CBD and other frameworks convention, like they are per se legally binding, but then you have to look at each provision and what they actually say. And I think that is the problematic. That's very hard to establish breaches because how the provision are formulated. So, but it's like just a slight disagreement. But yeah, so that's all for me. Thanks.
Thank you. So, I mean, Britta was asking the question in terms of indigenous people and local communities and countries that have not yet ratified. ILO stands for the International Labour Organization, and there is a specific treaty that refers to indigenous peoples, as you know. So, any last thought, Lena? I know you have to go, so if you could just give a last thought, then we'll go. And give the word to the.
I do have to drop off, but I believe Lucia and Harry have some great opinions that they're about to share in regard to Indigenous rights and treaty ratification. The last thing I would say is I definitely agree that it's piece by piece taking apart the articles of a convention, but I think that it's difficult to say because there is the Paris Agreement, which a lot of countries like America just like dropped out of, and because it is legally binding, and they're like, we're not going to meet that, so they just drop out of it, and it's becoming very frustrating. But I definitely agree that countries should be meeting these targets. They should be going above these targets. These are the minimum requirements. And I think that the involvement of Indigenous and local communities is really how you get there. I mean, there are so many self-declared Indigenous protected and conserved areas right now that honestly, if they were more respected and just legally protected, then they would really help to meet these both reconciliation and environmental targets and goals. So that's just my final thought, and thank you everybody, and I look forward to watching the recording to hear what else you have to say after.
Thank you. Lucia, some last thoughts? We're a bit running out of time, but any last thoughts you have?
Yeah, just to say a few words related to the to indigenous peoples, fundamentally responding to Greta, and also highlighting we have certain keywords that we have talked about during this session that we have to bear in mind when we want to implement at a national level what we have discussed during COP16. For example, mainstreaming, integration, commitment, and empowerment. Those 4 words are crucial in every step that we want to develop during the process of updating the NBSAPs, also implementing, but also empowering people, for example, in the terms of indigenous peoples. What we have in Latin America, I'm going to focus on a regional level. In Latin America, we have currently the Escazú Agreement. The Escazú Agreement is a very crucial treaty that we all agreed in Latin America that is going to be very, very useful to join what the CBD targets, what the CBD objectives and the Coming Montreal targets should be they should be done, it's useful to integrate with other regional treaties, and also bearing in mind that, for example, we have to be conscious that at a national level, commitment to recognize the voice, participation, and representation of indigenous peoples is transversal to a constitutional level, national level. It has to be included, not just a symbolic reference, as has been mentioned by the Women Caucus and also the Academic Caucus that I didn't mention before. For example, what in the Amazon region is already building what we call the Amazon Sacred Headwaters. The Amazon Sacred Headwaters can be similar to an OECM, and actually what they have done is to go and build from the scratch, from the constitutional level to legislation and policy and programs in every corner in the country. So what we have to do is to build from the framework at a national level, and to impact, to empower people that they have to also position themselves as right holders, so they can transform internal legislation and mostly implement it in an effective way. Thank you very much.
Thank you, Lucia. And I think that really connects well to the question that was raised in terms of what is it that we can learn from other regional processes. And I think the Escazú agreement that just Lucia mentioned, it's a terrific example. So, Kari, do you want to say just the last word?
I do.
And then we'll go and pass the word to Daniel. We have 2 minutes, so to say.
Totally. No, I got that. Thanks very much. Lucia, yeah, we were just talking about the Amazon Sacred Headwaters work this morning and how good it was and how to support that work. So that's cool. Yeah, just to say, look, on the voluntary versus legally binding, this has been a long and ongoing conversation in the context of the CBD, and I think there's merit on both sides, obviously. But as colleagues who are listening have heard from panelists, one of the drawbacks of it being legally binding is that then countries don't commit to them, basically. And I think you can look at the 30 by 30 commitment and say, would we have got anything near that if it had been legally binding? And so again, one can debate the pros and cons of these things, but I think looking at it like that is an important one. And so I would just close for you, Claudia, by saying, as we're seeing these growing attacks on international law, it's really a rallying cry to those of us who work in international law in partnership with many other people, to work across the conventions. We've heard about, working in synergies, promoting policy coherence and innovation at the national level, including vis-a-vis indigenous peoples and local communities, and then, working at those multiple scales as well in a joined up way. So I think if we can do that and be sort of interdisciplinary in our work, even whilst those attacks continue, we have the best chance of promoting some norms in the next 4+ years. Thanks. Claudia, back to you.
Thank you, Harry. And Daniel, as co-chair, do you want to give some last reflection?
Sure. Esteemed colleagues, we explore the role of OECMs, indigenous and traditional territories, and challenge ahead, including enforcement gap and regulatory fragmentation. We also explain the importance of mainstreaming conservation and the role of business in this effort, as well as the challenges some countries face on implementing the NBSAPs. Despite the challenges, there is optimism. Innovative legal and policy approaches worldwide offer valuable models for strengthening biodiversity governance. As we approach the closing plenary, let us carry this insight forward and work towards making the commitments of the COP into meaningful action. Thank you very much for your contribution, and I look forward to continuing the discussion in the plenary and beyond. Thank you very much.
Thank you so much, everyone, those in the room and also those of you hearing us online. This has been both difficult to hear, like kind of the challenges that we have ahead, but also just learning from each and every one of you. What are you doing from your respective perspectives, whether it's within the UN, within local communities, indigenous groups, international conservation, academics. It is in the way that we can work together to really achieve the target. So it's important that these processes are not only phrased as law, but law and governance, law and policy. And how can also not only law, but also other disciplines work together to achieve our outcomes.